Supreme Court judges have today concluded the hearing a hearing appeal in which the National Assembly, the Office of the Attorney General and the Cabinet Secretary for Treasury and National Planning are seeking the reinstatement of the Finance Act 2023, which was invalidated in July by the Court of Appeal. During today's hearing, parties opposing the reinstatement of the Act argued their case as the 7-judge bench led by Chief Justice Martha Koome also sought clarifications on key issues relating to the appeal. Arnold Adidi with a full report.
For the second day, through a virtual court session, lawyers representing the National Assembly, the Office of the Attorney General, as well as the CS for Treasury and National Planning, persuaded the Supreme Court to consider reinstating the Finance Act 2023, adding that the Court of Appeal acted in error by nullifying the Act in July. On the other side, lawyers opposed to the reinstatement of the Act, led by Charles Kanjama and Evans Ogada, argued that the National Assembly did not adequately conduct public participation before passing the bill.
So if something is null and void, it cannot be subjected to structural interdict. It cannot be subjected to a mechanism of nursing it into life. It is void for all purposes.
Consultation is a two-way relationship where citizens provide feedback to government. It is based on prior definition of what the issue is and what the citizens ought to respond to.
The Supreme Court judges led by Chief Justice Martha Koome also sought clarity on key issues relating to the appeal, including the issue on whether Kenyans were adequately involved before passing the now void Finance Act 2023.
By what means does the public receive information as to what may have happened to a bill between the third reading, when amendments are introduced, and presidential assent?
It seems like the Court of Appeal now raised the standard or changed the yardstick and introduced new parameters that were not anticipated in the FIVAN or the BAT. The question I'm asking is that a breach of the requirement of public participation?
The fate of this appeal shall determine whether or not the government shall apply the Finance Act 2023 in collecting revenue for the current financial year after scrapping the Finance Bill 2024 following nationwide protests against the bill. During the sessions, Senior Counsel Githu Muigai protested the Court of Appeal's decision, terming it as harmful to the state.
The judicature, without condoning breaches of the Constitution, should avoid radical rulings that imperil the stability of the state, which is exactly what the High Court did in this matter. When you defund the state by a single stroke of the pen, you defund the state. You empty its coffers.
Today's session marks the end of the Finance Act 2023 appeal hearing. As the 7 judges revert to their chambers, Kenyans shall be eagerly waiting on their judgment, which the court says shall be delivered upon notice. Arnold Adidi, TV 47.